on the value of advocacy in today's arbitration proceedings. A fascinating and vast topic, which we have decided to cover today, first by focusing only on oral advocacy and the cross-examination of witnesses, and by devising a few, we hope, provocative questions, trying to think a little bit outside the traditional box, or at least each of the cultural boxes. For this, we have 4 eminent panelists who will be debating 4 questions in pairs, one of them being more obviously from a civil law background and the other from a common law background, but you will hear that their positions are not necessarily tagged to one system or the other. Because, I'm sure you will agree, the world of international arbitration today is a bit more subtle than this division, including thanks to the work of arbitral institutions such as the ICC. What our debaters will also try to address as part of the answer is the overall theme of the conference, promoting the rule of law, and more specifically, what works best for the parties to be able to present or prove their case, but also what works best for the tribunal to reach the right decision. Now, let me introduce our panelists briefly. I will start with Sara Nadeau-Seguin, who's the only woman, so that's easy. Partner with Teynier in Paris. Sara initially trained originally in the wonderful city of Montreal. She's admitted here in England and also in Paris. She's a true internationalist, but she's agreed today to play the civil law practitioner role on the panel. She's got extensive experience in both commercial and investment treaty arbitration, also sits as arbitrator, and this is how one of her clients describes her, and I love sharing these quotes, as absolutely first class. That's Sara. Moving to Carlo, founding partner of the recently established XGIVS law firm in Sao Paulo, over 30 years of experience in international arbitration and litigation, and also practicing in international investigation relating to anti-corruption, anti-money laundering matters. He is described by Chambers Latam as one of the best, no less, and always a pleasure to work with. Welcome, Carlo. Harry Matovu doesn't need any introduction on his home ground. Called to the bar 35 years ago, silk since 2010. But when you search for Harry's profile, this is what you get. One of his key attributes is his ability, with great wit and charm, to metaphorically fix his hands around the throat of an opponent and slowly strangle them. Right. And everything he does is done with charm, grace, and wit. Now, a typical KC, perhaps, but I have to say, Harry, that made the rest of us feel a little bit ordinary. Last but not least, Jeff Sullivan, our second KC on the panel, also known to most of you, partner with Debevoise Plimpton, who is London-based, but actually originally trained in the United States, in Florida. Enormous experience as counsel, in particular in investor state arbitration and public international law. And my favorite quote for Jeff is that he is part of the Legal 500 UK Hall of Fame of International Arbitration. And I didn't know it existed, so...
Neither did I.
There you go. I thought perhaps you don't know, but your marketing department did a great job. So, welcome, Jeff. Now, more seriously, moving to the first question. First question is this, it will be debated by Carlo and Harry. Is oral advocacy only required because counsel's pleadings and witness statements are too long and not to the point? So what we mean here is this. With increasingly lengthy pleadings, are all openings and closing statements redundant or specifically, or precisely, essential to guide the tribunal? Would hearings be shorter if pleadings and witness statements were shorter and more focused? Does oral advocacy hinder or truly facilitate the tribunal's proper assessment and decision making? And I think, Harry, you are starting on this one.
Yes. Carlo's asked me to start, and I feel, having listened to the last session, a little bit like a tethered goat left in the village while the tigers are prowling, because what I'm going to say is, I hope, going to stimulate debate. You're all going to come at me, but I'm told that as with a tethered goat, the death is quite quick. So you can feast on my carcass in due course. Quite a lot of good Wagyu steaks come off this. Anyway, underlying the question that I'm asked to answer is the proposition, which seems to be accepted as a basic proposition of arbitration, or that arbitration has to be a speedy dispute resolution mechanism, because that's what commercial parties want, and we've heard this in the previous General Counsel panel. But what about justice? What about due process? What about the promotion of the rule of law? And let me put certain thoughts in your heads. International commercial disputes and investment treaty disputes involve, and this is largely not, I hope, controversial, complexity. Factual complexity and legal complexity. They involve, in many cases, long histories of relationships between one or possibly multiple parties. And this demands of tribunals the ability to unpick the history of a factual relationship between sophisticated parties. The parties have brought the complexities of their dispute to a tribunal because they're unable to resolve them in another way, for example, by mediation or negotiation. And so there are often in such disputes points to be made either way. That is the circumstance in which tribunals are asked to decide cases. And as well as the complexity of factual issues, there's a huge amount of law being made all the time. And I, having spent 30 years toiling at the commercial bar, say this with some feeling. There is far too much law being made, and it continues to be made all the time. And what is a tribunal, therefore, to do to resolve this? Who are the tribunals and the judges who have this unenviable task? They're often human beings, often, not always. Often human beings who are under time pressure, sometimes overworked, individuals who come with all the baggage of cognitive bias when considering a dispute. And those of us who are humans, all of us have imposter syndrome. So how are we going to deal with that as tribunals? With high anxiety and the pressure of self-criticism, or in some cases by masking it with what I believe is one of the biggest banes of the dispute resolution process, namely intellectual arrogance of tribunals and judges. And there's a challenge for you to pick up if you dare. And of course, those of us who sit as tribunals who are not human have intellectual arrogance anyway. What are we going to do with this? Give such people a written document to peruse without any oral advocacy to help them, without any discussion to help them, and we submit that you run the risk of injustice, judgments being made as to facts without adequate nuance, judgments being made without careful consideration of the complexities of human interaction, judgments being made in haste without a chance to try to shift the prejudices and the cognitive biases of those who have to decide them. And since the age of the sophists and Socrates in ancient Greek, oral advocacy, oral debate, oral sharing of views has been the way in which judgments are given soundness. And why should that change now? And we say that, in fact, we need that more than ever with the increasing complexity of the global economy and the disputes that arise from it. We need it more than ever with the increasing complexity of law. And quickly, what about due process? Listen to your customer. You heard Kai, Fabio, Kate in the session just before us. Parties, I submit, want to see tribunals at work. They want to see tribunals deliberating. They want to see that if they lose the dispute, they have at least had their day in court and that they have seen their case being discussed by a tribunal. So we can't and must not do away with oral advocacy. We'd be, first of all, kicking the crutch away from the tribunals who would welcome, and I as an arbitrator say this, who welcome the chance to debate a case with the advocates appearing before them. But also, there is an assumption that tribunals can properly decide the cases without oral advocacy. That's the assumption in this, in the question. And if that assumption is held by all of us in this room, I submit that that would be a supreme arrogance. That's what I want to say.
Thank you, Harry. So, Carlo, what have you got to say?
Well, it's hard to follow that. I kind of feel his hands kind of around my neck here a bit.
We're in violent agreement, Carlo, aren't we?
Absolutely, absolutely. And I mean, from speaking from my perspective, not only as a civil lawyer, but as a Latin American lawyer, a place in which arbitration is fairly recent, we can very much compare what used to be the dispute resolution system before the courts and how life changed when we started having access to the alternative of arbitration. So arbitration in Brazil, more specifically, started in 2001. At the time, we had a code of civil procedure that dated from 1973. Basically, a code of civil procedure that was passed during the military dictatorship in Brazil. Everything was done by a fora. All pleadings and submissions were in writing. The briefs were already too long. And arbitration gave us, and most of the countries in the region, the opportunity to appear before a panel of adjudicators who were chosen by the parties, and with the unique opportunity, not only during the hearings, but also on the execution of the terms of reference, for instance, on the discussion of Procedural Order 1, where you get to set the schedule of the case as you want, a real sense of democracy. So that was the feeling when arbitration started. And that was the tool that allowed us to, in a moment where the country was receiving massive investment because of the privatizations, to bring cases and to decide cases with the support of the international community in a globalized world and make the decisions more predictable. So I feel that now with 24 years passed since the beginning of arbitration in Brazil, that orality is key to finding justice, as Harry has put it. And it's a pleasure to be here speaking at the centenary of the ICC conference, because since Brazil, more specifically, is not a member of the Washington Convention, the whole notion of international commercial arbitration, even in cases involving the state and state-owned entities, has been done through ICC. So we learned how to do international arbitration with the ICC, the first international practitioners in the country sharing their experience and educating the local community were French, Professor Fouchard and Gaillard. So this, I think this, in a very short period of time, gave Brazil a boost, and now the country is the second one in number of ICC cases with Brazilian nationals. So this gives, only slightly behind the United States. So this gives a sense on how much, using the relative resource that you have in arbitrations is essential for solving complex disputes.
So since you both agree on this one, we're going to move to the next question. Hopefully, you won't all agree on the second question. The second question is my favorite. It was actually not my suggestion, but Anya's suggestion when we prepared for this session. We heard a lot about diversity this morning and the value of diversity. So the question is this: should arbitral tribunals composed only of English cases be banned? Now, the question does go, I think, to the common law value of oral advocacy and how it plays on a panel if you only have English cases, or how we call them on the continent where I'm based, Anglo-English cases, whatever that means, but I think there are a few of those in the room. And here are the questions, and the questions were, actually the sub-questions were devised by everybody on the panel. Are cases fundamentally biased in favor of other cases? Should you have to instruct an English casee or appoint one on the tribunal if your opponent has done so in order to be heard? Does this apply only to London-seated English law-governed arbitrations? Where does this leave foreigners in the field of international arbitration? In London, are we sometimes missing out on an essential element of diversity for a better decision-making process by having a casey only composed, English casey only tribunal? Is this a cultural issue? Is this a generational issue? Quite a mixed bag of questions, which luckily I don't have to address now. Sara and Jeff will do so. I think, Sara, you're starting.
Thank you, Domitille. I sensed a bit of discomfort when the question was read out, and I will say I do feel a bit of discomfort having to argue to this room full of very established cases that they should be out of a line of work and a source of income. But I will do it without, despite the challenges to my own practice and without prejudice to my silk application one day. Because I do believe the question we have to be asking ourselves is not what is most comfortable for us as legal practitioners, but what is most likely to promote the rule of law. And I put it to you that the English QC tribunals are not likely to promote the rule of law. They're not conducive to promoting the rule of law. And I have 4 compelling reasons, which I will put to you hopefully quickly. The first is very simple. It's in keeping with today's theme, and it has to do with procedure and the way English cases will approach evidence. English cases will be biased not only in favor of other cases, but they will be biased in favor of an adversarial approach to arbitration. The English casey tribunal will expect to receive witness statements by witnesses that the parties, not the tribunal, has identified. These witnesses, you know the drill, of course, have been written by or with the help, sometimes with a very heavy pen of lawyers. At the hearing, there will be virtually no examination in chief before these witnesses are tendered to the other side for cross-examination, and off they go, Godspeed. During the cross, the English casey will typically step back and watch because it will not want to give the impression that it is sending a lifeline to a witness in distress or coming to the rescue of a weaker party. And this, to use Anya's quote of this morning, might make for amusement of the audience, but I put it to you that it is not about erudition, and it is not about promoting the rule of law. The first problem is identification of the witness. In the civil law system, the tradition is that the decision maker, the judge or the arbitrator, plays a much more proactive role in identifying the witnesses that he or she wants to hear from. And I put it to you that this makes a lot more sense because it is the actual decision maker saying, well, I want to hear from that person. The next problem is the lack of evidence in chief. The English casey tribunal does not want to hear evidence directly from the witnesses. It would much rather read the prose of lawyers trying to sound like witnesses and trying to anticipate what the tribunal might want the witnesses to say. And all that with a lot of Latin maxims at about every paragraph, because let's face it, old habits die hard. And then finally, we get to cross-examination, which is equally problematic for reasons that I will come to today in the last debate. And it gets worse because English cases are not only biased in favor of the adversarial model, they're also biased in favor of a very specific adversarial model, and that is one that is infused with notions and unwritten rules of what is done in English court practice. And this is very problematic because it leads to discrimination against advocates that are not familiar with these rules and that do not use them. So in response to your question, Domitille, if you're appearing before a tribunal of English cases and your other side, the opposing side, has an English casee, then you might as well get yourself a good English casee because otherwise you're going to lose out. But that doesn't mean that the system is working. It means that it's very good at self-perpetuating, not promoting the rule of law. My second argument relates to legal truth. Very often we think about arbitrators in a way that is completely detached from the law that they're applying. And actually, in the question that you asked us to address, there's no mention of what the applicable law would be. And I put it to you that if the applicable law is a civil law, French, Swiss, then it's a terrible idea to have a tribunal of only English cases for the simple reason that they might get it wrong. There are very significant differences between the civil law and the common law approach. And just because they're experienced English cases does not mean that they will get it right. And I can give you a very easy example. Contract interpretation is very different in the common law and in the civil law traditions. In common law, the rule is you look at the contract, and the contract is the law of the parties, and you look at the wording of the contract. But in civil law tradition, in contrast, we're really looking at what the intent of the parties was beyond what they wrote in their contract, because they might have not been very clear at expressing their actual intentions. And I think a tribunal of English cases might find it difficult to get its head around this very different approach. There's also the approach of there's also the issue of the approach that the tribunal will have to the law. In common law jurisdictions, the idea, the adversarial idea, is that the parties come with their legal arguments. And that's very different from the civil law system, in which it's said that the decision maker comes to the table with his or her own understanding of the legal issues, and indeed that can even extend to legal research. And so if you're appearing before a tribunal of English cases, I put it to you that there's a risk that they will not apply the law correctly just because the parties have not argued it, and the English casey tribunal will not go and research the law independently. My third argument is a very easy one to sell. It's diversity. If everyone is thinking alike, then no one is thinking. Diversity in arbitration is not just a moral imperative. It's also a vector of better decision, period. And finally, I think I still have a little bit of time. I'll be quick. My fourth reason is language. And I think language comes in two different ways. The first one is relatively straightforward, and that's discrimination. Most English cases will be English speakers, native speakers, and on top of that, they will speak in a certain accent, and they are therefore likely to discriminate, consciously or not, against non-English native speakers, and particularly against advocates that speak with a certain accents. Because we're getting tired and I think we need something fun, let me share an anecdote with you of a colleague of mine who was trying to get everyone to concentrate on a particular issue. And so he said to the tribunal, "We have to focus." And luckily for us, the tribunal was not composed of English cases. There were a lot of French speakers on the tribunal who immediately understood that what that advocate was trying to say was, let's focus. And that was all fun because it was a cute French accent. But the reality is there's a hierarchy in how we approach accents. And some accents are not deemed as convincing as others. And so this is particularly challenging when you're appearing before English cases. The second way in which language comes into play is less straightforward, but I think absolutely fascinating and troubling. There is scientific evidence that shows that the language in which you are being asked to make a decision actually has an impact on the decision you are about to make. So if you are being asked to make a decision in a language that is your second or your third language, the studies show that you reach a decision that is more emotionally detached, that is more rational and more utilitarian. So for these reasons, I put it to you that you should not be appointing tribunals of only English cases, and in fact, they should be banned.
Thank you, Sara. Very interesting, the last point. So, Jeff, what have you got to say to that?
Well, I'm a QC with a Florida accent, which is a little bit unusual. Harry may feel the hands around his neck.
I'm going to focus.
So Sara makes some very good points. I think many of those points, I think the fundamental problem with many of the points that Sara makes is they also apply to a tribunal made up of 3 Swiss arbitrators or 3 Singaporean arbitrators. Is my mic on? Can you hear me okay? So the same arguments apply. So the question, I think, if we take a step back, we're looking at civil law versus common law traditions. Is there something particularly problematic with English QCs? That's really what this comes down to, that differentiates the way they approach cases as opposed to those from other legal traditions. I don't think that's the case. There may be others who disagree with me on that. Fundamentally, it's a question about bias. We do, of course, have rules already dealing with bias in arbitrations. There's guarantees as to independence and impartiality of arbitrators. Those rules aren't perfect. They may not necessarily apply to the issues we're discussing today, but we have those rules. We can't ban a particular national from sitting on a tribunal because they may come from a particular tradition, is my view. The second point I'd like to make is I think we need to give all of us who practice international arbitration a bit more credit. And the panel is a really good example of the diverse backgrounds from which we come from. We have a Canadian practicing in Paris, a Floridian practicing in London, a New Zealander practicing in Geneva. So we're used to seeing different styles. We're used to dealing with different national laws. And arbitrators, by and large, I'm an optimist here, but decide cases based on the facts and the law and not someone's accent or the particular way they approach contractual interpretation. That is something we need to take into consideration, and really let's all give ourselves a little bit more credit and not just assume that the bias is there. We have control as to who sits on our tribunals. The first step, of course, is when the contract is agreed. If you want to put in a prohibition on folks from a particular background, you can do that. That was an issue that came up 10 years ago in XGIVS. But we know now that you can place restrictions on the nationality of the arbitrator, for example. So that's there. You have control in the selection process. We all profile arbitrators before we select them. We know to a degree what it is we're getting. And then the institutions, of course, are the ultimate backstop to ensure, and the SEC is a great example of that, of ensuring that the arbitrators are fit for purpose. So the real question, I think, then comes down to something that's been alluded to, which is the unconscious bias, right? So not the bias that may necessarily win you a challenge to an arbitrator, but there may be English KCs who really can't stand the voice of an American advocate. I may be familiar with that. The reverse is also true. There are a lot of American arbitrators who get really annoyed by English barristers. It does exist, but I think part of the challenge we all have as advocates in international arbitration is we have to adapt to our tribunal, right? We're all going to make decisions as to how we present a case based on our panel, based on the facts, based on the relevant rules of contractual interpretation, for example. That's what we do. That's our sort of day job. Now, there may be instances where you do need to bring in co-counsel from Switzerland or Singapore or an English KC, but that's okay. I don't think anything's wrong with that. This is international arbitration. We're dealing with cross-border problems, and it may require to have people from different backgrounds on your counsel team. So I think I'll leave it there. I guess the last thing I would say is that the one thing I agree with Sara on is the diversity of thought. That is a useful thing. I think it was Matthew Syed who said the only time you want 4 clones is if you're putting together a 4x100 relay team, then you want 4 Usain Bolts. Otherwise, you need people who think differently. But that, I think, is a slightly different issue, what we're talking about here.
Thank you, Jeff. Very good points about unconscious bias. We talk a lot about it, but I'm not quite sure what the solution is to deal with it, including when you consciously think about it, when you start on a tribunal. Very, very difficult. Third question. Let's move away from counsel and tribunals and talk about witnesses. Our third question is, do witnesses always lie? And if so, is it counsel's fault? Now, there's a very famous French arbitrator, Serge Lazareff, who used to say, witnesses always lie. That's just that he paid no attention to what witnesses said. That was a bit of an extreme position, and next debaters will consider whether witnesses always, often, rarely lie, intentionally or not. And is the issue the lengthy witness statements prepared or polished, I should say, by counsel? Is it the inevitable memory failure? Is it the will to please? Is it the over-preparation or coaching in some jurisdiction before the hearing? And how can those shortcomings in the testimonial evidence in international arbitration be addressed to serve the rule of law? And I think for this debate, we have Jeff again with Carlo.
Yeah. I mean, I can be very quick. I know witnesses don't lie because they all take that oath right before they testify. And they tell you they're not going to lie. Look, I think we all accept that witnesses sometimes, I don't want to call anyone a liar, may tell half-truths. They may spin the facts in such a way that it's more favorable to their case. I mean, that does happen. So I'll focus a little bit more on the second part of the question was, is it counsel's fault? Because I think that's probably a bit more fun. So the instinct is to say, no, it's not our fault if a witness doesn't tell the truth. But I think it might be. And we need to think very carefully about our role, our involvement in witness selection and witness preparation. So there's two aspects to this. We're involved generally in selecting witnesses. Not always, but many times the lawyers are heavily involved in determining who's going to stand up and appear as a witness for the case. You don't go looking for liars as part of that process, but you might look for people who understand the background, who get the positions we're taking in the case, and therefore may be more predisposed to spin the facts in a way that's more favorable to your case. It's an adversarial process we all want to win. So that's the first place we need to be careful, is in witness selection. The second place is prep. And here the civil law, common law debate is an interesting one. It doesn't fall neatly on civil law, common law lines. Italy, France, I think Belgium effectively ban meetings with witnesses. Germany allows witness preparation. In the UK, we have something called witness familiarization, which is not witness coaching, according to the Bar Council Code of Conduct. In America, you might commit professional negligence if you don't coach your witness, right? So the drivers are very, very different. Mock cross-examination is commonplace. So we've got different ethical rules. There's been a lot of effort, I think, to try to find a level playing field by different organizations. ICA's published a code of conduct recently for practitioners. Ultimately, though, I think most of us will say we're never going to tell a witness to lie. At least I hope none of us do that. So the question is, are we subtly encouraging them to spin the facts in a particular way or tell a half-truth? And this is, I think, where we need to be really, really careful in both the selection process and also in the preparation process. I know there are advocates for banning witnesses outright. You may hear a bit about that today. I don't know, from Toby. But I'll say this, that's not going to happen anytime soon, so it seems. Until then, let's not forget that even a lying witness has value to the tribunal, because you then know what is not the truth, at the very least. So there is value, even with a lying witness.
Yes, well, the usage of witness statements is something also new to civil law countries who were traditionally used to the inquisitorial system, right? So the witnesses would be summoned by a judge who would be the one asking the questions after interpreting the questions that were put by counsels on opposite sides. We have been using when a project goes wrong, you get layoffs, people are disconnected to that specific project or line of work. So we also often use witness statements on the preparation of the cases to remind the witnesses of what was going on the ground as the crisis emerged, leading to litigation. And this is something that, considering the complexity of issues we face, we find very useful, and we learn to apply these practices over time with common lawyers, just to be able to present the witness with the documents that may be useful in order for the witness to be deposed in the future. There's a lot of debate still to this day whether the counsel appointing the witness can ask questions to the witness at the hearing. It does sound rehearsed. It does sound that there has been preparation involved when that happens, but it's something that arbitral tribunals, especially in Latin America, are reluctant in banning, because it may become an issue of violation of due process and a ground for the awards to be vacated in the future before local courts. But other than that, I think I completely agree with Jeff that you need to trust the system. So there are measures for lawyers to be held in contempt if they instruct, coach, or manipulate the witness. There are measures that are being applied when you allocate costs on the awards to avoid those kinds of guerrilla tactics. And I think that this is more useful than simply banning all witnesses together. I think in that situation we would be, I think that we would be close to what Harry just called intellectual arrogance. Right?
So, Carlo, you agree again?
Yeah,
so you didn't follow the rules of the game.
That's why I get those quotes from Chambers.
Thank you. Now, I think this is a difficult one, and I have to say, as arbitrator, when you get a 150-page witness statement, polished, drafted by counsel, and we see more and more of that, in particular, but not only in investor-state disputes, it does make the work of the tribunal very, very difficult. And I do. Going with the rehearsed answer, and I do think counsel have a massive responsibility in this and need to get their hands off those statements a bit and their hands off these witnesses, and focus a little bit more the evidence. It's a huge challenge when you have that coupled with 5,000 documents and you're trying to reconcile all of that. What is true, however, is that in my experience is that witnesses do sometimes lie, but I don't agree with Serge Lazareff that they always do. I think they do sometimes lie because they want to please, because they can't recall, because they've spent so much time thinking about the case that things get they start thinking, what do I need to say to get there, not counting when they really have skin in the game. And the role of counsel is to make sure they don't lie. And for me, that's what witness preparation is about. But anyway, I don't know what you're going to talk about, Toby, but I know this is one of your pet subjects, so I'll move on to the last question. The last question is also about witnesses, and it's a pet subject of one of my former partners, Michael Schneider, who's now senior counsel with our firm. Michael, this one will make you laugh. Should cross-examination by counsel be banned and only tribunals be allowed to ask questions? and you've sat with Michael, so you'll remember what he thinks about that. And here the issue is this: are tribunals ever sufficiently knowledgeable and prepared to ask the right questions to the witnesses? How can they do that without showing some form of bias or prejudgment? Do witnesses stop lying when the question comes from the tribunal? Does the value of witness examination in challenging or illicit evidence depend on very specific techniques, and therefore only counsel or only tribunal have those techniques and should do it? And which rules of evidence better allow the truth to come out of the witness mouth? Close, open questions, etc. So I don't know that Harry and Sara are going to address all of these questions, but Sara, I think you're starting.
I'll start. And I'm not as agreeable as Carlo, so my mission as the civil law lawyer on this panel is to convince you that cross-examination by counsel should be banned and only tribunals should be permitted to ask witnesses. Now, I know this is a tough sell, but hear me out. This is how it's done in the civil law tradition. There is a historic distrust of witness evidence in most civil law jurisdictions because the idea is that witnesses lie, deliberately or not. That's a separate debate that we can have, but they lie. And so when the questioning of witness is done, and it's extremely limited, it's primarily, if not solely, conducted by the judge or the decision maker. And this, I put to you, is way more likely to lead to the truth and to promoting the rule of law. And the way it is done in the common law system by counsel isn't. And in understanding why, I think we have to remember how we are told that cross-examination should be performed. And I remember when I was a junior lawyer, I was given 2 golden rules that I had to hold on to as if my life depended on it in cross-examination. That's number 1, you control the witness. And number 2 is you never ask a question if you don't know the answer. And because of these rules, what we get on cross-examination are very closed questions, very suggestive questions that are literally putting words into the witness's mouth. And if the witness tries to give an explanation, usually what happens is counsel will ask the tribunal to instruct the witness to give a yes or no answer and then to add a very brief explanation. You also know that a lot of hours will go burning the midnight candle into carefully drafting these questions with the hope that the witness will actually accept the proposition that's in them. And so we're not asking, Harry killed the goat. We're asking, sorry, Harry killed the goat, didn't he? And we're not asking what happened to the poor goat or what did Harry do? And as a result, the witness is not given an opportunity to provide a full picture of his or her recollection of the facts. He or she is being cornered through a succession of usually rapid-fire questions into admitting facts that he probably doesn't really recall in the way they're being described. And the style of counsel questioning has another pernicious effect, is that it really becomes an exercise in stamina and resilience, because enter an aggressive English KC, present company excluded, or an aggressive counsel, and it really becomes about how well is the witness prepared to withstand the stress of cross-examination. It's really not about the truth or about an accurate recollection of the facts.
It's called good lawyering.
Because of the second rule, which is you don't ask a question if you don't know the answer, I find that most advocates will stay clear from facts that are deemed dangerous if they don't know the answer. And these facts can be material to the case, they can be material to the decision the tribunal has to make, but they won't go there. And usually when it's examination led by counsel, the tribunal will not go there either because it wants to respect how the parties have designed their cross-examination. And after all, that's the rule, right? It's for each party to put its case forward, and may the best man win. The flaws of cross-examination led by counsel, I think, are also compounded by the practice of commencing witness examination with virtually no examination in chief. And I've alluded to this a bit earlier today. The tribunal does not even hear from the witness at all. the witnesses just being pushed into this cross-examination exercise that is extremely problematic in itself. And I think some will say that the solution to this is re-examination. Whatever damage is done to the witness on cross-examination can be cured on re-examination. But I think we all know that, or at least I will put to you, that re-examination is actually a very limited tool to redeem a witness, because the witness is tired. The witness probably is having a difficult time understanding what evidence you're trying to get from him or her with these extremely large questions. And also the last thing you want to do after a very effective cross-examination is stand up and say, I have a list of 25 questions for this witness, because that doesn't signal that you have a lot of trust left in that witness. So for all these reasons, I put it to you that if the objective is to get to the truth, then you're much better off with a system in which the tribunal is free to engage directly with the witness, no style of questioning, no pre-written witness statements, just ask the witness questions about the relevant facts and do it in a way that is the most natural possible. I think tribunal-led questioning also has another advantage, is that it allows the parties to read the tribunal's thinking. The parties will see where the tribunal is going, if they need to correct misunderstanding, if they need to correct misinterpretations about the record, and guide the tribunal a bit more in its decision-making. I suspect that it will be argued that one of the reasons why tribunal-led cross-examination does not work is because tribunals don't have sufficient time to prepare. And to this, I would say two things. With all due respect, I think the same thing happens with counsel-led cross-examination. How many times have we been sitting on a cross-examination and you think you've just marked a great point, and you look at the tribunal and you realize they just don't get it? Because to be able to follow really precise cross-examination, the amount of work and preparation that needs to be put in is humongous. It's really a lot of work. And so because tribunals don't get it on the spot, then we have the need for either closing submissions or post-hearing submissions, which if the tribunal could just engage directly with the witnesses, we wouldn't even need. And the second point I would make is also that if the issue is helping the tribunal prepare, well, certainly there's things that the parties can do to do that. They can send tribunal a list of questions or identify facts that they would like to put to the witnesses. So just because it's more difficult for tribunals, I think, is not a sufficient answer. And I think, in fact, the perspective of having to question a witness might help the tribunal prepare even better for hearing.
Thank you, Sara. Harry.
Yes. I suspect it will be argued. The tiger's in the village, and so this tethered goat must bleat. We all lie. We all lie. It's not just in cross-examination that we lie. We lie when we try to get out of the washing up. Everybody lies. It's a part of the human condition. The question, therefore, is really whether cross-examination is damaging for the process in which we are indulging as parties and as advocates or not. In my submission, the answer is emphatically no when you consider what exactly we're trying to do with cross-examination. We're not concerned about bias. Well, I'm not concerned about the bias that might be shown during cross-examination, whether it's conducted by advocates or by a tribunal. I come back to the point I was making earlier in my violent agreement with Carlo at the beginning of this session, when I said that I'm a skeptic about tribunals, about the ability and the power and the understanding that tribunals have about every aspect of a case. I remain skeptical when I look at cross-examination. Tribunals need and welcome the assistance of counsel, both in oral advocacy and in the examination of witnesses, even if questions are put to them by the advocates for them to ask of a witness. They have less time with a case as a tribunal. They haven't been in the case for as long as advocates. The parties have had months and years on it. And even so, we who do cross-examination know, as Sara has just said, how much work and effort has to go in to asking questions, whether they be closed questions, whether they be aggressive questions, or whether they be questions which are seeking in a more open way to examine what the witness's position on a point actually is. It is hard work, and we mustn't just simply offload that work to a tribunal, even if we put the questions to the tribunal for the tribunal to decide. But we can argue about all the ways in which we could give this work to tribunals. But again, I want to consider with you the underlying premise. What are we actually trying to do with cross-examination? Are we really trying to get to the truth? Is that what cross-examination is really about, if we're honest? My submission is that's not true. If we really thought that cross-examination was a good way of getting to the truth of any matter, we would be in cloud cuckoo land. It's one of the worst ways of getting at the truth. If a tribunal is asking questions of a witness, even questions put by the advocates, it's a terrible way of getting at the truth. So what is witness evidence and witness questioning about? And I suggest to you a point which I made earlier. If we look at it as a point of due process, then we may be able to understand and make better use of witness questioning. Because in a due process system, which is led by the parties' desires, the parties want to see that their cases have been put and that the other side's case has been questioned and thoroughly explored. That should be the purpose of cross-examination. That should be the purpose of any witness questioning. The idea that it's getting at the truth is nonsense. And the whole idea of a dispute resolution mechanism is that the parties agree that whatever the truth of the matter, and there are both two sides to every argument, whatever the truth of the matter, they agree that in order to get a resolution of their dispute, in order to allow the transfer of money in a commercial arbitration from one side to the other or not, this system, imperfect as it is what they have agreed to accept. So let's not see it as an attempt to get at the truth. Let's see this as an attempt at due process to resolve a dispute. And both parties will go away from the dispute thinking that their truth of the matter is the ultimate truth, the biblical truth. You won't shift them from that. But as long as the loser feels that it has had its day in court, that its witnesses have been able to put a story, that its witnesses, its advocates have been able to question the other side's witnesses, and that the tribunal has not descended into the arena, but has stood, listened, and deliberated and reflected in an award the process by which they have come to the resolution through which the party has lost the case, then that is acceptable. That is the rule of law. It is not a chase for the truth. That is for dogma.
Thank you, Harry. These are nice concluding remarks. I always think this debate about the truth, is it not that the issue is not we're trying to find the truth, but whether the claimant's case is established. That's more the way I look at it for my part. Now, I know it's 12. You're looking at your watch, Toby. We started a bit late. I suggest we do two things. We start before the round of applause, think about question. I think we've got time. Take a couple of comments and questions. So big round of applause first for our panelists. Particular thanks to Sara, for having played the role she played. She was a little bit reluctant about doing this, being in common law territory. Huge thank you. There you go. Another round of applause. Any question? We've got time for a couple of questions of comment. Yes, sir.
Tony Marks, RTD Chambers. I'd like to hear Harry defend the attack on a QC panel. And I would also like to promote the idea of a solicitor on a panel has a more pragmatic approach sometimes than KCs.
I'll be very short. I've participated on three-man KC panels the worst sort of panel in some people's views, and also on much more diverse panels. I have found that the individuals participating in those panels have been very much the same in their approach to the case and in their resolution of particular issues. I do, however, acknowledge, going back to the point I made right at the beginning of my comments, that there is a certain type of senior English lawyer who parades sometimes an intellectual arrogance, and I'm sure that that is the case all the world over. The seniority of a lawyer does tend to lead to an idea of perfection of judgment, and we must all guard against that.
Thank you. Any other comments? Guy. Might take 3.
I can't help referring to Harry's tethered goat analogy, but in a slightly different way. Is there a risk that a witness is a tethered goat when it comes to cross-examination? And is that a fair way to treat a human being?
Guy seems to be looking at me, but...
Well, we did talk about strangling at the beginning. So.
He was.
It's not a fair way to look at the system. If you accept the premise that I was putting to you, that arbitration and litigation are dispute resolution mechanisms which are not looking to get at the truth, but simply to resolve a dispute in the way that the parties have agreed or in the way in which the state has designed it, then the system will also have rules by which the game has to be played. And one of the rules by which the game has to be played will be that you will not bully a witness. You will not torture a tethered goat. I accept that the goat is tethered for the purpose of the system, but that's the way the rules are designed, and that's what everybody has to accept when they call a witness to give evidence. But the rules should be designed to prevent that iniquity.
We'll take one last very short comment and then we stop.
Thank you. Going back to the previous panel where we heard from the users of arbitration and the general view of improving the speed of arbitration, are there any thoughts from the panel on common law versus civil law approaches to using advocacy in a more effective and efficient way to improve speed of arbitration? And that's both written and oral advocacy I was referring to.
So sticking to oral, because that was...
Yeah.
Jeff.
I guess one thought that came to mind in respect to the last question is if tribunals are doing the cross-examination, that's inevitably going to take a lot longer. Because, as Sara said, the amount of work and preparation that goes into that process, and requiring 3 arbitrators to do that and come up with a way by which they efficiently then cross-examine, so to speak, a witness is going to be a slow.
But Jeff, the combination, your witness who, after 20 minutes is going around in circle and counsel going around in circle, and we all know how it works. The tribunal asking one very direct question, not worrying whether it's open, closed, or whatever, just wanting to know the answer, is a very quick way, an efficient way. And I would suggest that well-prepared interventionist tribunals actually leads to saving an awful lot of time, at least at hearings. And perhaps to answer your question, certainly in our part of the world where I'm based now, our hearings tend to be a lot shorter. And you're really struggling to get a Swiss arbitrator to agree to a 2 or 3 week hearing. I think we must stop. It's a great debate, but we have a fantastic speaker after us. So before we leave him the floor, another huge thank you to our panel.
Well done, you.
I hope